Your Honor, my name is Charles Dunn, and I represent Liliana Valencia, who is the next friend for the minor child, Ruth.
Thank you.
Chris Rhodes for defendant, Dustin Rockwell Knoll, Your Honor.
Thank you.
Luke Dow, guardian ad litem.
All right. Mr. Dunn, would you like to proceed? Oh, wait, let me swear in our interpreter. All right.
Judge, I'm desperately looking for my client. I don't see her on Zoom. She should be in the North Austin office. Do you see her? Liliana Valencia.
Charlie, I don't see someone labeled as such.
See if we're on page 2.
Well, I don't think we can. Let me, Luke, I've talked to her. She knows about this hearing. And I know you've talked to her, the North Austin office. Judge, can we pass this right now? Let me go find her and make sure she gets signed in, and then we'll come back. I apologize for the inconvenience.
Oh, that's no problem. Maybe it might be better if Miss Poe put y'all in a waiting room. I don't know. Or you can just turn off your cameras and your mics.
Yeah, I'd just rather stay on this so that we can get her
Okay.
done when you get to it back to us. And I apologize. I'll find out where she is. She might have got held up in traffic.
And Your Honor, Mr. Dow and I are here on another hearing on your docket.
Honor, I have contacted my client. She had forgotten about it. She's getting on her cell phone. She's gonna get on the link. And we're walking her through that now with
Okay.
a Spanish-speaking paralegal in North Austin. Apologize again.
That's fine. Then I'll go up and take the dog attack unless that's her.
We did just have an iPhone join us, Your Honor.
Do you want to see if we can go? Okay, yeah, that's probably her. I think the dog attack's going to take a little bit longer because I was confused reading it. And I couldn't find anything about the show cause and appear. So I just read the petition. So I think that's going to take a little bit longer. So this iPhone is actually the plaintiff in the Valencia case. That would be good. Hello, Miss Valencia. How are you?
Señora Valencia, ¿cómo está?
Bien, gracias.
Good,
Okay.
thank you.
You're not driving, are you?
Usted no está manejando
No.
ahorita, ¿o sí?
No, ya me parqué.
You're
No,
parked.
no, I
Okay.
already parked.
Okay. And now remind me, because, you know, I'm old. Did we say we needed a hearing record or not?
I do not unless the carrier does, Your Honor.
No, we don't need a record.
Carrie said no. Okay. All right, great. Then you may proceed, Mr. Dunn, if you have any kind of opening, and then I'll swear on your witness.
Okay, I have no opening, Your Honor, and our first witness would be Liliana
You may
Valencia.
proceed, Mr. Dunn.
Ms. Valencia, we are here today about an auto crash involving your minor daughter, which occurred approximately 2 years ago in July of 2022. Do you remember that crash?
Sí, lo recuerdo.
Yes, I do.
And your daughter's name that we're here about is Ruth, is that correct? And was she injured in that crash and received medical treatment for which we are here about today?
Correcto.
Correct.
And how old is your daughter today?
She's about to turn 9.
And has your daughter fully recovered, in your opinion, from her injuries she sustained in the crash?
Pierde el equilibrio.
Apparently so, but as I had mentioned it to you last week, after the crash, I've noticed that she falls all of a sudden. She will lose her balance.
And are you aware that the insurance company, on behalf of the driver, has offered $40,000 for a settlement for your daughter?
Sí.
Yes.
And you have signed some paperwork indicating that you believe that will be a fair settlement to compensate her for her injuries. Is that correct?
Sí, está bien.
Yes, that's fine.
And you also have been explained that out of that $40,000 will come attorney's fees of 33%, which is $13,200.
Correcto.
Correct.
And you also understand that we will be paying her medical providers out of this settlement the sum of $2,368.18.
Correcto.
Correct.
And we will also be reimbursing Medicaid directly out of the settlement, the sum of $525.98. Do you understand that?
Yes.
And you also understand that there were expenses that we incurred in order to bring the lawsuit, serve the defendant, take depositions, those types of things, in the amount of $1,957.62.
Okay.
Okay.
And that leaves a sum of $21,948.22, which is going to be put into an annuity for your daughter. I've explained that to you, and has the ad litem explained that to you.
Okay, perdón. Sí.
Oh, okay. I'm sorry. Yes.
And I've explained to you that when your daughter turns 18, for 4 years, she will get 2 payments a year of $4,453.51 so that she can pay for college.
Okay. Sí.
Okay. Yes.
And you understand that money is guaranteed to be paid regardless of what happens to your daughter.
Okay. Sí.
Okay. Yes.
And do you believe, based upon what we have discussed, that this settlement is in the best interest of your daughter?
Sí, está bien.
Yes. That's fine.
And do you agree that if we went to court, you might get more money, you might get less money, or you might get no money? But if you accept this settlement here today, that money will be guaranteed for your daughter.
Ahí nos quedamos.
That's what we agreed.
And Ms. Valencia, do you want the judge to approve this money for your daughter here today?
Sí.
Yes.
Your Honor, we would pass the witness.
Mr. Rhodes?
Yes, Ms. Valencia, you settled the part of the case with regard to your injuries also. Isn't that right?
Her adult daughter was the driver. Ms. Valencia wasn't in the lawsuit.
I'm sorry. There was another part of the lawsuit that was settled with regard to your adult daughter, correct? Thank you, Charlie.
Yes, sir.
Let me restate the question. There was another part of the lawsuit that was settled with regard to your adult daughter, correct?
Sí.
Yes.
You understand that after the hearing today, all the claims against the driver, Mr. Knoll, and the insurance company will be over, right?
Correcto.
Correct.
Pass the witness.
Mr. Dow?
I don't have any questions, Your Honor. Thank you.
All right. I wasn't real sure, and maybe, I was looking at something else or writing or something, but the money's going into the registry or into an annuity, but she doesn't get it till she's 18, right?
No, it goes to, there's going to be what's called a qualified assignment, which means the insurance company, which is Travelers, will assign to an A++ rated insurance company. It's called Pacific Life and Annuity. Everybody knows about that company. They will be responsible for making these payments when the child turns 18. And there'll be 8 payments, and there'll be $4,453.51.
I got that part. I don't know. My brain bleeped out for whatever reason. I was writing or something, and I didn't hear about what it kind of sounded like she was gonna start getting it right away, and I'm like, wait, she's 8. No.
No,
So,
I don't
okay.
think Mr. Dow does a terrific job as an ad litem, and I want you to compensate him within reason, and Mr. Rhodes is pulling his hair out. But neither he nor I could do something like that. And so we have made this so the child will get all of this money, but not till she turns 18. And it'll have interest on top.
Okay, I just wanted to make sure because, you know, sometimes you mishear things sitting over here.
I agree with plaintiff's counsel. Everything he said is correct. While depositing the money into the registry might have been an option, the parties agreed with a structured option.
Okay, and that's approved. Thank you all very much.
Thank you again, Your Honor, and I'm sorry for the inconvenience. Mr. Interpreter, will you let Mrs. Valencia know she can sign off?
Absolutely.
And
Señora
that
Valencia, ya
the
termi-
settlement was approved.
Yes, Your Honor. Señora
Okay.
Valencia, las preguntas ya terminaron. La señora juez ha aprobado el finiquito y le dice a su abogado, el abogado Don, que ya se puede retirar.
Ok, gracias.
Buenas
Thank
tardes.
you.
Buenas tardes.
luck to
Thank you.
you.
Bye.
Gracias.
Okay. Thank you, Mr. Salazar. Now,
It's a pleasure.
Mr. Yes, thank you. Very competent and very good at what you do. We really appreciate you and having to wait, and thank you again. Now, Mr. Dunn
Thank you.
or Mr. Dow, who will be sending the order judgment?
Your Honor, I uploaded it to Box and then I thought I'd emailed it to Miss Latham, but apparently I didn't attach it and I'm having some email issues. So I will be responsible for getting that emailed to Miss Latham.
And-
Okay.
Luke, do you have your fee plugged in there yet?
I did put it in there.
Okay.
It was,
Your Honor, we would ask that Mr. Dow's fee be approved as put in the judgment with Mr. Rhodes' approval.
Yes, and of course, Your Honor, that will be paid above and beyond the 40,000. It does not come out of the settlement in any way, shape, or form.
Okay, that's approved. And what is it? It's usually 1.5, but
it's $17.50.
1750. Okay, got it.
We have inflation these days, Judge.
Well, yeah, I felt like I just don't know that he's definitely worth it.
Yes, he's a
a
great-
little raise there is definitely warranted.
Thank you.
All right, thank you, and Allie will be looking for that.
Is sticking around.
Well, y'all have
I
a
am
great
on that
rest of your
Yanez
week. I think that.
dog bite case, Your Honor.
Oh, okay. Well, that's the next one.
Okay.
Y'all need a record on that?
No, Your Honor.
No.
Okay. Like I said, I had a little trouble with this one, trying to figure out what was going on. I mean, I know that anyway, I know what the plaintiff's allegations are basically, but I couldn't find a motion to show cause and to appear, and whether that's correct or not, I don't know. So, because that's just what my docket said to look for in the case file. So 7 Yanez versus Doe et al. The docket sheet says this is a motion to show cause and appear. Please make your appearances.
Good afternoon, Your Honor. Jack Holtzman here for the plaintiff.
Thank you.
Chris Rhodes here for defendant WMCI Austin 3 LLC.
Okay, just that one defendant.
Yes.
Okay. And the ad litem, I guess, is Mr. Holtzman.
Your Honor, this is actually this is a motion for substitute service on.
Oh. Well, that makes it totally different. I don't know why they put motion to show cause and appear. So motion for subserve. You may proceed.
Your Honor, my client, Ms. Yanez, she was attacked on February 1st, 2023 by 2 pit bulls owned by Miss LaShondra Vaughns, aka Karen Washington. She was a tenant at an apartment complex, and Mr. Rhodes represents the management of the apartment complex. We've tried attempting to serve Miss Vaughns 5 different times with 2 different service agents. And so in our motion, we've got 2 affidavits with 5 different attempts. The first attempt on February 8th, second attempt February 9th, third attempt February 10th, fourth attempt February 13th, and then February 16th of this year. The first attempt was made on February 8th, and they spoke with the youngest son that confirmed that she lived there. The service agent gave the son their card. There's another attempt on the 9th, spoke with a male in his 50s or 60s, and they saw the dog inside of the house, and he said that she lives there, not home. And then third attempt, spoke with same 50s, 60s male, and said she did not come home last night. But Your Honor, it's just, we've documented our attempts, and we're asking for a substitute service by leaving the amended petition at her address, or giving it to someone there that's over 16.
All right. Any responses?
Defendant basically takes no position with regard to the motion for substitute service, and does not object to the motion or the court signing an order for substitute service.
Okay, well then that is granted. Thank you, because I was looking for something that's a show cause and appear. I don't know why they wrote that in there. But yeah, that's a much, I bet you were like, I wonder why the judge is so confused about this easy subserve issue. But anyway, so I did kind of skim that too while you were talking, and it looks like it's all in order, so that's going to be granted. Do you have a proposed order?
Yes, Your Honor. And I could show you right now on the screen.
Okay.
Of course, my computer's freezing up. One sec.
Takes a little long, but we're not, pauses don't. I did my first 2 years on Zoom, so we're used to what we used to be able to call pregnant pauses. I don't know if we can call them that anymore, but anyway, might be offensive. I don't know.
Well, my
You never
computer's
know.
I think I'm showing the right screen now. So basically, here's just a proposed order, and it's just asking for leaving it at the front door or leaving it with someone over 16 at that address.
Okay.
Your Honor, usually we'll have them mail it by regular and certified mail to that same address as well, but otherwise looks good.
Okay.
Okay. Would you mind doing that, putting in there, on your Word document or whatever, adding that you're also, certified mail. You're sending it by certified mail and first class mail, as well, so that everybody's bases are covered and you don't ever have to worry about that again.
Yes, Your Honor, I will. I'll add it and then I'll submit it to the court. What's the best email?
Miss Latham is copied on the email from which you received this link.
Okay.
So if you just reply all, or I can spell it out for you.
Okay, I'll find it. I appreciate it, Your Honor.
Yeah, it'll probably populate once you start typing in Allie, but you can see her name there somewhere. Yeah, right there, like the 5th Brady Bunch square. So that's Allie.Latham, and then the name, the regular naming convention of Travis County TX.gov.
Right. Well, thank you. I'll be sending that shortly.
Well, great. Thank you for your patience.
Thank you. Have a
I
great
hope
day.
everybody, all the dogs ended up to be okay, right?
Well, not my clients, but
No.
right.
Thank you, Your Honor.
I thought I read far enough. It's just like a movie where the dog dies. If I can see a dog's about to die in a movie, I turn it off.
Right. It's always sadder when it's the dog.
I know. Isn't that weird? It's just a strange little thing. Like they can, all these people can be, whatever. But when if the dog's gonna pass away in the movie, I'm just like, I can't handle it. I can't handle it. Well, thank you all very much, and I hope it has a good resolution for everybody.
Appreciate it.
Y'all have
Thank
a
you,
lovely week.
Hi, Your Honor.
too.
I'm here for the
Thank
movement.
you.
Louis Marchetti in his individual capacity. I have a motion to withdraw and substitute in Insurance Defense Counsel and a motion for continuance of trial date.
Okay. Do y'all need a record? Do you need a record?
I do not, Your Honor.
This is Nicole Wade for the plaintiff, Joan Cambron. We don't need a record either. And I also have our paralegal, Jordan Strickland, on as well.
Okay.
That's a good point. I think we have a couple of attendees as well. I don't know if they want to announce themselves. Rebecca Wesley is here for the co-defendant, Waller Building Company. And then I have the substituting in attorneys may also be on. Dennis Dresden and Michael Brown is here for David Dubois. So
Yes, Your
I
Honor.
think they're all here.
Your Honor.
Attorney in waiting, Your Honor.
Okay, great. So, all right, Cambron versus Marchetti et al. This is a continuance and a motion to substitute counsel. Please, well, we already did really appearances since we don't have a court reporter on this one. So, you may proceed.
Your Honor, the parties both uploaded exhibits to the box. I don't know what if the better procedure is to take them one by one or just offer them all now into evidence for what they're worth. We have 7 exhibits, but mostly it's we're just pointing to the plaintiff's pleadings in the case. And so I guess I'd offer our exhibits 1 through 7 into evidence.
Okay, I can go ahead and take judicial notice of them. So it's movements 1 through what?
We had 1 through 7.
All right, so I've taken judicial notice of that. And they were also attached to your motion, correct?
No, we didn't have any evidence attached to our motion. Plaintiff filed a 172-page response, and so yeah, so I just have uploaded them last night.
Okay, I will take judicial notice of those. Okay, you may proceed.
And then what I've done is dropped them into a PowerPoint deck, just because I'm better at that than working with exhibits. So, Your Honor, this case is number 66 on the docket for April 15th. The 66 on the jury docket as of this afternoon. In this case, plaintiff, this is from plaintiff's production, lives in the house on the left, is suing her neighbor, Lou Marchetti, who lives in the house on the right, both as trustee of the trust, which owns the property, and now individually, as well as Marchetti's general contractor who built the home, Waller Building Company, LLC, and she's suing for alleged damage to her property. Plaintiff filed suit on February 26, 2021, complaining about erosion that was occurring along this fence line during Waller's construction of the project. She initially sued Waller. She sued the trust that owns the property next door, but not Lou Marchetti individually. She also sued the architect and the engineer. Waller addressed those erosion issues she was complaining about by stabilizing the soil and installing a retaining wall under the fence that you see. Waller also has agreed to make drainage modifications to the draining wall. I'm sorry, to the retaining wall that's on Lou's property. Lou is my client, to prevent water from impounding on plaintiff's driveway. To implement those modifications, Waller would need plaintiff's agreement and plaintiff to allow reasonable access via her driveway. Plaintiff has not agreed to the modifications. In December 2023, plaintiff first named Louis Marchetti individually into the lawsuit. Lou Marchetti is asking to
What day?
On December 11th, 2023 is when plaintiff added Lou Marchetti individually to the lawsuit.
First time.
Yes.
Okay.
Lou is asking to substitute in his insurance defense counsel and for a continuance of the April 15th trial date because plaintiff amended her lawsuit December 23 to add him individually. There's also new allegations against Lou Marchetti individually that have triggered his homeowner's insurance coverage. Plaintiff's counsel in the response accuses me of seeking the substitution of insurance defense counsel for Marchetti individually for purposes of delay only. But plaintiff's amended pleadings added Marchetti individually and necessitate insurance defense and this continuance. Otherwise, I have no desire to postpone the trial. Good cause exists because plaintiff added an insured defendant, which is Lou Marchetti individually. Insurance has assigned new attorneys of their choosing. New counsel needs to substitute in order for insurance to appear in mediation. New counsel needs obviously more than the next 15 days to prepare for trial. Lou Marchetti, trustee of the Hook'em Heels Trust, which has been a defendant, is not insured. If plaintiff non-suits the new claims against Lou Marchetti individually and goes forward only against Waller and the trust, then I wouldn't be asking for the continuance and substitution. Plaintiff's argument is that I wasn't diligent and I waited too long to report the lawsuit to insurance. Therefore, in plaintiff's opinion, insurance should have denied the claim and Lou should not get the benefit of his insurance to help defend or settle the claims against him. I respectfully disagree, and this is the reason. To trigger liability coverage, plaintiff had to sue the insured, Lou Marchetti individually, and claimed that an occurrence has resulted in property damage, new property damage, during the policy period 21. That means June 2021 to the present. The policy period began in June 2021 when Lou moved into the home after the project was completed, after the erosion issues had been addressed, and when he acquired a homeowner's insurance. Plaintiff's original lawsuit in 2021 was while Lou's house was under construction. The plaintiff sued and served the trust via its former trustee, Adrian Alonso, and the allegations had to do with trespass and erosion issues that are occurring during construction. There was definitely no coverage for this. The defendant was the trust, which held title to the property, didn't have insurance, and the allegations were of property damage occurring during construction in 2020 and 2021 before Lou's policy period. The lawsuit was based on Inspector Bob Wellborn's report, which was attached to the petition, and they identified mid-project conditions, and the allegations were of continuing erosion during Waller's construction period. The Wellborn, after the Waller had installed, you see here two pictures that appeared in a civil engineer's report. The picture on the left shows the mid-project condition. The picture on the right shows the condition as it was stabilized after retaining wall was put in by Waller. Plaintiff's engineer, Saxon Loomis, had said that the retaining wall needed to be modified to prevent surface water from impounding on the plaintiff's driveway, and so we, defense, agreed to address the drainage issue. And this was the civil engineer that was recommended by Saxon Loomis, Jay Campbell, and he developed 3 design concepts for plaintiff to choose from. Plaintiff chose a concept, the defense agreed, but plaintiff ultimately rejected Campbell's final drainage modification plan for the retaining wall. Then Saxon Loomis in 2023 had offered to do a final plan of the necessary changes, including a restoration to the driveway to address plaintiff's concerns about Waller's replaced backfill not being sturdy enough, and to do a survey to ensure that no regrading of Lou Marchetti's front yard was needed to address the drainage issues. We then filed for a motion for summary judgment for the trust on IDID in August of 2023. The petition was and still is complaining about mid-project conditions. The trust didn't control the means and methods of construction, and by that time in August, we had agreed to do modifications to the retaining wall to prevent future ponding of water, and so it didn't seem like there were any issues left. The first amended petition was filed after that motion was filed, and here you can see they continued to refer as damages. The plaintiff continued to refer to the Wellborn report, which was a report about mid-project conditions. And they still didn't sue Lou Marchetti individually. It does appear that they tried to sue Mr. Alonso individually and as trustee. But again, the allegations had completely to do with erosion during the construction period, which wouldn't trigger coverage. And then the second amended petition here's where plaintiff named Lou Marchetti, and it did make a reference to to plaintiff experiencing impounding of surface waters during rain events. But I didn't read any explicit allegation that there was property damage resulting from impounding of surface water. And so at this time, plaintiff would say, well, why didn't you make a immediate report to homeowners insurance? Well, because property damages references were still just back to the Wellborn report. So, which occurred during construction outside of the policy period. So it made more sense to me to add a motion for summary judgment for Marchetti individually, including a statute of limitations argument that in December 2023, it was too late for plaintiff to sue Marchetti individually in tort for alleged damage that occurred during construction. Then you have the third amended petition. It's really, as far as these issues go, it's the same. There is a reference to impounding of surface water, but the damages hark back to, the conditions that have been there since the construction period. So we all agree, and we always have agreed, to modifying this retaining wall to prevent temporary ponding or puddling on the driveway. But to me, a puddle isn't proof of property damage. And plaintiff's response to the motion for summary judgment still largely complained of erosion that had occurred, or things that had occurred during construction in 2020 and 2021. And at the hearing is where plaintiff's counsel made it very clear they consider the drainage issue to be causing property damage, meaning a puddle amounts to property damage. I don't think there's any evidence of that. That's under consideration in the motion for summary judgment, which is still pending a decision. But that's not the issue today. What the issue today is that was the first time that I really knew that they were alleging that there had been new damage occurring post June 2021. And so at that time I started investigating, since while the MSJ has been pending, made the report to homeowners insurance, and they've accepted coverage, and here we are. So in conclusion, plaintiff non-suits her allegations against Lou Marchetti individually. We can proceed with April 15th. Otherwise, Lou Marchetti individually is a newly added insured defendant who should be entitled to have his homeowner's insurance substitute in as counsel. And there needs to be a continuance for his new counsel to conduct discovery and prepare for trial. Thank you.
All right. Thank you. Ms. Wade, your response?
Yes, Your Honor. We also have a PowerPoint, and Jordan is going to share her screen and pull that up. As she's doing that, I will note that plaintiff did file her suit 3 years ago. At all relevant times, Mr. Marchetti has acted on behalf of the trust. During these 3 years, including December, when Marchetti alleges and opposing counsel that he was first made aware of these allegations, no discovery has ever taken place. So not from the trust, not from Marchetti. So even if we rely on this December 2023 trigger date that we've been talking about, why wasn't there discovery in those 3 months? And why are we here 3 weeks before trial trying to get that discovery? And what discovery is Marchetti individually going to propound that could not have been propounded in the last 3 years, as he was a representative of the trust and the trust was a party? Perhaps if this was the first trial setting rather than the third, plaintiff would be more amenable to a continuance, but this property damage, she started raising the issue with defendants in 2020, and here we are in 2024, and there's still no resolution. Additionally, in regards to the additional discovery that Marchetti says that he needs in his individual capacity, the motion is void of any argument as to what discovery that is and whether counsel used due diligence to obtain that discovery. So on that point alone, the motion fails. To give you some context, Your Honor, this dispute, as we've been discussing, arises from damage to plaintiff's property, and the distinction between the trust and Mr. Marchetti individually is important because the trust is the owner of the real property and Marchetti built his residence there. Jordan, can you start clicking through the PowerPoint? So we see Ms. Cameron lives at 1500. Mr. Marchetti lives next door. Importantly, the Hilcomb Hills Trust is the owner, and that's also shown by the Travis County Appraisal District. So in 2019, Mr. Marchetti contracted with co-defendant Waller Building Company to build his residence. As we see, prior to Mr. Marchetti's construction, we had a quaint single-story residence on the property. And that's the smaller gray residence is what existed before Mr. Marchetti built his residence. That residence was demolished in order to construct Marchetti's residence, and here's what we see in its current state, as opposing counsel noted as well. Mr. Marchetti's backyard has a basement, and to construct that basement required significant excavation. So the arrow we have pointing here is towards plaintiff's property. The fence separates the two properties so we can see how significant that excavation was and how close it was to plaintiff's property. And running adjacent to that excavation is plaintiff's driveway. We see, so this was one of the engineer's photos from 2018. In 2020, that's okay, you can go to the next one. Thanks, Jordan. Ms. Cameron started raising these issues. Jessica Hargest, that's Mr. Marchetti's wife, sent an email to her design and construction team noting that she and Mr. Marchetti were both done dealing with the neighbors, but she acknowledges there was a mistake and says we need to fix the mistake on our part and move forward. Moving into 2021, this is a similar picture to what opposing counsel showed. We see significant erosion at the property line on the Marchetti or the trust property, and then we also see erosion on plaintiff's driveway. And then well into 2023, the end result of that deep excavation, as well as the construction of the retaining wall itself between the properties, has led to, in addition to the prior erosion, significant water impoundment. And Your Honor, you can see the area of plaintiff's driveway near the retaining wall and near where the excavation occurred has significantly more water impoundment than the side of the driveway that was further away from the actual construction. Before diving into more detailed procedural events, I will note for the court, this is the third trial setting. So the first trial setting was October 2023, and the parties passed that. The second trial setting was February, and the third trial setting is again 3 weeks away. Providing a bit more detail, so plaintiff filed her suit in February 2021. A few months later, plaintiff had her engineers from Sachs and Loomis issue a report in May 2021. And here we see that Sachs and Loomis opines that the construction was substandard, the approach to remediation was not developed, and as constructed, the current driveway on plaintiff's property wasn't providing adequate load-bearing stability or proper rainfall management. And they also point out to the physical drainage structure configurations that need to be removed. A month later, the trust filed an appearance, and 1 month after that, plaintiff's engineers at Sachs and Loomis issued another report pointing out that the proposed repairs from the defendants were inadequate. So again, the temporary backfill had to be taken out, and they also pointed out several items that the proposed repair did not address. And Your Honor, I will note that on plaintiff's exhibit list, the Wellborn report that Mr. Hicks is referring to is not even our exhibit list. The expert reports that we have are the Sachs and Loomis report 1 and 2, and then some subsequent reports that relate to new plans that plaintiff had drawn up because there was some back and forth on whether Waller would do the repairs, and they eventually said no. So that's why she made those plans, and that's what the subsequent engineering reports relate to. So I do want to point out that as far back in 2021, the trust vis-a-vis its representative, Mr. Marchetti, had these same reports. So the allegation that there's something new doesn't really bear a lot of credence in my mind, because in these same reports, the engineers are talking about water code violations and water impoundment. So the fact that maybe that wasn't appreciated until recently or wasn't clear until this summary judgment hearing or an amended petition, I think is a bit of a red herring. These reports were provided before the trust made a formal appearance, and they complained of and pointed out the water impoundment that we want to go to trial on, in addition to the erosion that occurred during construction, which then led to the water impoundment. If we jump forward a few years into 2023, the parties had their first mediation scheduled, and at that point, neither Lou being Mr. Marchetti, nor the trust wanted to participate. So it was just Waller and Plaintiff at that mediation, and there was no settlement. The parties passed on the first trial date and then agreed jointly to a trial date in February 2024. So at this point, the trust had noticed through the First Amendment petition that plaintiff wanted to hold the individual of the trust liable, as well as in his capacity as trustee. So this December trigger date, I think, again, is another red herring, because the third amended petition clearly stated that the trustee was part of the lawsuit individually and in the official capacity. And it was just, we thought that the trustee was Mr. Alonzo instead of Mr. Marchetti. After the parties agreed to this February 2024 trial date, defendants reached out to plaintiff and they asked if she would agree to another continuance so that the parties could remediate and Ms. Cambridge could give her deposition. And at that point, plaintiff did not want to agree to another continuance, but she recognized the value in trying to, one, remediate the case, and two, allowing for her deposition. And again, this is December after the third amended petition. Marchetti individually and trustee agreed to this exact trial date that they're wanting to continue. So at that point, the parties scheduled a second mediation for February 29th, and Mr. Marchetti unilaterally canceled that because he didn't have a coverage determination. Again, even though these allegations were apparently obvious to counsel in December 2023, we don't have a motion for continuance until 2.5 months later, which puts us at the hearing today, 3 weeks before trial.
So
Give me one. Oh, go ahead.
you said that in February 2024, defendant Marchetti was named in the amended petition.
That would have, so in October, plaintiff named the trustee individually and in his trustee capacity. And Jordan, if you'll bring that up very quickly, it was just at that point, we thought that the trustee was Adrian Alonzo rather than Mr. Marchetti. And so this is October 2023. You can see in the caption, we've added Mr. Alonzo, and it clearly points out individually and as trustee. At no point in October 2023 did Mr. Hicks bring up this issue of making the trustee individually liable. Plaintiff amended in December to name Mr. Marchetti as we found out that he was the trustee. And Jordan, will you move to the second?
How did you come up with Alonzo as trustee?
He was the former trustee.
Okay, but was that conveyed to you in discovery?
I don't recall how we found out that Mr. Alonzo was the trustee. It might have been in some paperwork. And then we later realized it was Mr. Marchetti.
Okay, because usually that kind of stuff is spelled out in disclosures, right?
Correct. And that was not in any of the trust disclosures. We can pull those up shortly. Every time the trust issued disclosures, it said that the trust believed that the parties were named correctly and that the trust's name was correct.
Okay. Thank you for clearing that up.
Of course. So going to this insurance issue, and Jordan, if you will move slide 8. So Mr. Hicks has made, next one, please. So he's made a big deal about not knowing about these allegations and the occurrence until recently. However, as I pointed out earlier, he's had these reports from the experts since 2021, and the second Saxon Loomis report was issued approximately a month after Mr. Marchetti acquired homeowners insurance. So if we take these from the 2021 policies, we see that Mr. Marchetti and his wife are the named insureds. The premises location is the trust's real property, and the insured location means the residence. So I don't honestly care whether Mr. Marchetti has insurance coverage or not. My point is the trigger date isn't December 2023, it's 2021 when all of this was happening and plaintiff issued those engineering reports. And at that point, the insurance applied to the real property that the trust owned. And so my point in all of this is this delay of 3 years of trying to get insurance isn't the plaintiff's fault. Again, we don't care if there's coverage or not. Our point is that the prudent thing to do would have been to file this claim with the insurance 3 years ago, but that wasn't done. And now plaintiff is being punished in the form of a delay when this has been going on for several years. Additionally, one of the grounds for the continuance is to purportedly seek a docket control order and remediate the case. This case has been going on as I'm a broken record for 3 years. There's never been a docket control order. Plaintiff tried to move for one in 2022, and the parties never entered into one. I don't know why getting a docket control order at this point would be beneficial, especially when plaintiff was willing to give her deposition after discovery closed. And as we've seen, even after Mr. Marchetti knew he'd been individually named, he at no point in this litigation was interested in mediating. So again, allowing time for him to mediate when he could have done so at twice in the last 6 months isn't sufficient cause. The cause for this is that Mr. Marchetti wants to proceed with the benefit of having insurance coverage cover the mediation costs and potential settlement. But again, that's not grounds for a continuance, just that he has this personal preference to not have to finance the litigation. Oh, hello.
Sorry, I was just
okay.
trying to get something from my.
You're fine. Plaintiff on her end would have loved to not finance this litigation, especially in light of all the delays and postponements that have occurred. And she's actually at great personal sacrifice incurred over $100,000 to pursue this litigation. So it's quite frustrating to plaintiff that Mr. Marchetti, who had the ability to finance a $2 million house, wouldn't participate in the litigation in a meaningful way until he had insurance coverage. And that leads to the fourth point about discovery. Again, in the case for 3 years, no discovery from the trust at any time, either to plaintiff or to any other defendant or non-party. Plaintiff's deposition has never been taken. And the rules of civil procedure and the case law require that if Mr. Marchetti is saying that he needs a continuance to get additional discovery or evidence, he needs to articulate what that evidence is, show why it was material, and then explain that he used due diligence to obtain that evidence. And in the motion, we don't see any argument of due diligence. And I think it's very clear the reason we don't see that argument is because there's been none. Again, even if we believe this December 2023 trigger date, why weren't discovery requests sent in those 3 months? Why wasn't plaintiff's deposition taken? Again, it falls back to Mr. Marchetti's preference to not have to finance his defense, but that's not just cause for a continuance, especially when we're at the third trial setting. So again, plaintiff has no opinion or preference for Mr. Marchetti to have coverage. And as to the substitution of counsel, if we can proceed with the trial date as is, then there's no objection. But the substitution of counsel and continuance go hand in hand. Is there actually sufficient and just cause to allow the continuance when the reasons for getting the continuance, one, don't meet the procedural requirements of Rule 252 and aren't based on, these diligence efforts to defend the case or to take discovery. It's just, well, Mr. Marchetti doesn't want to defend the case on his own. And now that we're 3 weeks out from trial and it looks like there could be some liability, now it's time to get serious and engage in the case. And plaintiff has been taking this case very seriously from the get-go. And I don't think it promotes justice to allow for the continuance.
Okay, so let me ask Mr. Hicks, what discovery have you propounded? And if you haven't propounded discovery or requested the plaintiff's deposition, why not?
Your Honor, there's another defendant in the case. The primary target of the lawsuit was Waller Building Company. They've been leading the defense. I am the trust attorney, and after today, if you grant the substitution, I'm still the trust attorney. Trust merely owns the property. So there's been a lot of discovery conducted in the case. As far as I'm concerned, if they non-suit Loom individually, everything that's been done to date is sufficient. Waller wants to take, the plaintiff's deposition, we can do that. Unfortunately, they added Lou Marchetti individually. They're now claiming recently for the first time, and actually, if you read these petitions, show me where it says that damage has been caused since June 2021. New damage has been caused. We agreed from the get-go we were going to address the drainage issue. At no point was the petition clearly amended so that it would be, Lou Marchetti, you are on the hook because you have failed to address the drainage issue, and that has caused property damage to Ms. Cameron's property. It wasn't clear to me until the summary judgment hearing on January 17th that is what they're saying. The case has been about stuff that happened during construction all along, and with respect to diligence and putting heart and soul into this case, I found the civil engineer who created 3 concepts for Ms. Cameron to look at. I then paid their expert to finalize the plans when she rejected the civil engineer's plans. We all want to address the drainage issue. It is absolutely not Lou's fault that there haven't been drainage modifications. The question is not whether I was on notice of there being a drainage issue that needed to be addressed. I've been working on that for years. The issue is, when were the allegations changed to allege that there was damage during the policy period that Lou has had insurance on from June 2021 to the present? When were those allegations made? And I didn't read them, but that argument was made at the summary judgment hearing. It clarified that that's what their new allegations against Lou Marchetti include when they now refer to the impoundment of water. It's not just that this will be in the future, that it's occurred and it's caused damage. That was new. I've been diligent in trying to get insurance, and here we are.
Your Honor, to answer your question, there's never been discovery propounded to Ms. Cameron.
That's not true. I have personally, because I've heard.
Okay, so there either has or there hasn't. So
there's been no written discovery propounded to her. We have not prepared any responses or failed to prepare responses. James, correct me if I'm wrong.
The plaintiff has made disclosures, and it's all we need to know. All we need in this case. And Waller.
If that's all you need, then there's no continuance.
Well, I am not new counsel. I've been studying that. I've been working on the case for 3 years.
Okay, let's hear
Lou
from
is
Mr.
entitled to have
Dresden.
Lou's insurance is entitled to appoint their new counsel and have them prepare the case for trial. There are new allegations.
Okay, let's hear from Mr. Dresden.
Hello, Your Honor. What I know is we have a defendant who has insurance, and a carrier has asked me to look into potentially substituting in for that particular defendant. That defendant was joined into this case less than 4 months ago. So I don't know anything about the facts of this case. I've seen pictures today that I've never seen before. There's allegations that are being made that I don't know how valid they are, to what extent Mr. Marchetti had anything to do with them in his individual capacity. These are allegations that are made against him individually. And if we're being forced to go to trial within 4 months, I mean, even an expedited trial allows 12 months of discovery. I can't speak for what Mr. Marchetti might have been aware of or might have been tangentially known about throughout the discovery of the trust and of Waller. But once you name an individual and make allegations against that specific individual, then that person is entitled under the rules to have discovery to figure out what it is that is being alleged against him. And I think it's only appropriate to have the time to be able to do that. Now, I don't know when the discovery period ended in this case or if it's supposed to end, but or has it ended? But if the discovery period is ended by the time that he's been added in his individual capacity, I think there's prejudice for him to be able to conduct a proper defense in his on his behalf. Now, if they want to drop the cases against him individually, that I think Mr. Hicks has made that clear, then he doesn't have a problem with the trial setting. But if we're going to move forward with claims of individual liability against Mr. Marchetti under the circumstances where he has less than 4 months to conduct discovery, I think that's prejudicial.
Your Honor, again, if we rely on this December 2023 date, it still begs the question, why wasn't there discovery sent on Mr. Marchetti's individual behalf in December 2023, in January 2024, in February 2024? We talked about giving plaintiff's deposition. It was noticed she was willing to do that. So my frustration is, okay, fine, he's entitled to his discovery. What diligence was taken in this time period from this December date they want to rely on until now? None.
When was the answer of Mr. Marchetti individually?
Mr. Marchetti, go ahead.
Go ahead.
Sorry, go ahead.
Mr. Marchetti individually, I first filed a special appearance and answer because he hadn't been served, but we of course decided to appear for him at the summary judgment hearing in January. But the answer was filed in January, just before I filed his motion for summary judgment.
Which judge has that one? I'm assuming under advisement.
Judge Gary Gamble.
All right. So
And if I could make one last point on the summary judgment, Mr. Marchetti moved for summary judgment individually. Part of that summary judgment was no evidence. So implicitly, in moving for no evidence summary judgment, he's telling the court there's been an adequate time for discovery, so much of an adequate time that the court can go ahead and decide this on no evidence. So I don't know how there was enough time for discovery for Marchetti individually to move for no evidence summary judgment. But now, again, when it looks like there might be some liability, oh no, let's restart the clock. Let's go get discovery.
Your Honor, if I may, that's a bit disingenuous. If Mr. Marchetti didn't make an appearance in this case in his individual capacity until January, I apologize. I was mistaken. We have less than 4 months. We have 2 months, and discovery has to be done before 30 days before trial. So there's absolutely no way that Mr. Marchetti in his individual capacity or as counsel for him can be ready for an April 14 trial setting. I don't know when we could be ready under the circumstances, but again, asking somebody to have a claim being made against him, make an appearance, and then go to trial within 2 months is, again, it's prejudicial, and I think that's reversible.
Well, yeah, I was thinking mandamus.
Yes, that too, Judge. But I didn't want to throw that out there.
Nobody really likes that.
No, they don't.
Knock on your door.
Your Honor, let's not forget that in December 2023, Mr. Marchetti's individual counsel agreed to this trial setting on April 15th.
But he didn't know at that time that he was going to be sued in his individual
Yes,
capacity.
he did. That petition was filed December 17th, and we agreed to the trial date on December 29th, approximately 2 weeks later. Jordan, can you pull that up? I believe it's on the slide with the timeline.
Judge, I don't dispute that this is true. And the reason that I decided, as I talked about when I went through it the first time, is I read the third amended petition that's still a live pleading in this case. It is very unclear to me that what's being alleged falls into the damage occurring during the policy period. The fact that there's been and so that is the reason we move forward with the summary judgment hearing instead of thinking insurance. Now, when we had the summary judgment hearing, and it was clarified to me that in fact plaintiff believes that there is damage that has occurred because of water impounding on her driveway, and that's Lou's fault. If that's the allegation, then it occurred to me that this is now falling into the world of insurance, and I reported the claim.
James, the report from May 2021 from Saxon Loomis says water impoundment.
No. We've been addressing it for years. It doesn't mean you're alleging that property damage has occurred to Ms. Cameron's property on account of that.
Okay.
The issue was brought up before the policy period. We've been working on this. I have paid your expert to come up with a final plan for this, which now your client wants to jettison.
Your Honor,
the fact that we're aware of the issue does not mean that you are alleging a property damage occurring during the policy period.
Well, okay. All right.
Your Honor, if I,
If I
Just-
were, no, because y'all announced for 30 minutes. I'm sure we
Yes.
should go in 30 minutes. Let's see. Now, if we were to say you're number 66, I don't think you're going to get reached anyway. Honestly, whoever gets reached at 66, I've never seen that happen. Have anybody here, even that's not in this hearing? I mean, so I don't know. What date would you be seeking, Mr. Dresden? If we had that up, let me look and see. Does anybody have the Travis County jury trial list handy dandy?
pull that up, if it looks like we're leaning towards a continuance, I would ask that we be specially set.
Well, I can't do that. I don't think.
Your Honor, I have the jury schedule if you'd like it.
And Your Honor, with my docket, I've been setting things beginning in the first of next year, actually, is where my calendar is right now.
First part of 2025.
Yes, Your Honor.
I'm not gonna give you that. That's unreasonable. Especially since this is an agreed setting. And I mean, I'm sympathetic to that position, but it's kind of murky as to when all this happened and whether discovery could have been going on. I know that Mr. Hicks is standing firmly on his issue that sorry, I'm trying to look at this and also so April, May, June, July.
Your Honor, this is Rebecca Wesley for the co-defendant Waller. The summer for us is incredibly booked with trial settings, and also lead counsel already has vacation notices on file. We were hoping to look into September fall range for resetting of this trial.
Okay.
July works for plaintiff.
September?
July,
I know, but Ms. Wesley said that she's not available in July.
I believe she said that lead counsel isn't available. They have several attorneys on the case. I mean, if I would prefer to not go into the fall. This has been going on a long time. I'm not gonna.
Your Honor, lead counsel has the vacation notice on file. We have other vacations for our attorneys that are working on this case. That's why I said into the fall.
What about August?
Your Honor, if it was going to be in August, it's going to have to be really, really late.
You have a jury August 19th. Jury week is August 5th and August 19th.
One of those summer vacation notices is on that week, Your Honor.
Which week, Rebecca?
The 19th. Well, and the week before that as well. We don't have full weeks for that.
How many days is this set for?
3.
Just 3 days?
I'd be shocked if that would be done in 3 days, but that's just me, Judge.
Well, yeah, you've got multiple. Yeah, I would be shocked. I was shocked. 3.
We would agree to more. And Your Honor,
September 9th.
What about September 9th?
I mean, I'm at the mercy of Your Honor.
Well, I know, but we're trying to figure something out where it's fair. I mean, I'm sympathetic to your position, but I'm also sympathetic to Mr. Dresden and Ms. Wesley. And, you know, obviously there's, you know, a late designation of an individual. We can't just, that lawyer couldn't even propound discovery right now to have it admissible for because what is it? That's the 25th of March, and then your April 15th, you wouldn't even be able to propound any discovery. You'd just be going in with nothing.
Exactly.
So
right, but that's a big difference between when we were looking at July 2024 versus now September. So if it's going to be September, we will well, I'm sorry, I just received a note from my client. She's going to be out of town in September.
The whole month of September?
I'm not sure about that
Okay.
at the moment.
All right, then this is what I'm gonna do. I'm gonna grant a continuance to the parties to come up with a date where everybody is available and doesn't have vacation letters and doesn't whatever. And everybody's experts are available and the plaintiff can be deposed and all of that, but to occur before on or before October 7th. That's the first jury trial setting in October. So that gives y'all something to work with. And that's going to be the order of the court because we're not going to go into 2025. And summary judgment might be granted anyway. Who knows? I'm sorry. I was just curious. It's not like I was going to pick up the phone and call Judge Garrett Gamble. We're not a appellate panel here with, or anything like that. So, but that gives people enough time to do discovery. And since we are a central docket, I will put in there, since we're a central docket, I can't just say no more continuances will be granted for any reason because I'm only one of 12 people. And so I will put a sentence in there, any further continuances will be disfavored. Unless we add more people, and then they won't be disfavored, right? So that's the ruling of the court. Who wants to do a proposed order? I guess you won, Mr. Hicks and Mr. Dresden. So Mr. Dresden will be substituted in for Mr. Hicks. Is that correct?
And as well as Mr. Dubois, Mr. Brown is here from Mr. Dubois. There's actually 2 insurance policies during the time frames that we've been talking about, Judge. So you have 2 carriers. So we'll have 2 separate counsel joining in on
I'll
his
get
behalf.
that discovery done. Draft me up an order in Word and send it to my staff attorney, Miss Latham.
Your Honor, could you, repeat the deadline for the trial date? I believe you said on or before October 9th.
7th. The first jury week in October is the 7th. So you can set it on the 7th of October or before, but not after.
Can we? Okay, that's good. Thank you.
Okay. All right. Thank you.
Thank you.
Everybody
Honor.
was so, yes,
Well, it's a
that's
pleasure to meet you.
great. Anyway, thank you. I hope y'all all have a great week and we'll get to the rest of the docket now.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Y'all take care. And y'all know where to send that, right, Miss Latham? At all. This is a motor vehicle accident. Please make your appearances for the record.
Good afternoon, Your Honor. Gayla Corley for Starbucks.
Sandy Leiser for the 2 Cleanscapes defendants.
Jessica Cartwright for the plaintiff, Berlinda Olivo.
Anthony Pejere for Northwood Partners, Aquila Management Services, and Sage Land Company.
John Hicks for the Brightview defendants and WLE LLC.
Katie Andre for defendants, McGarriel and Accent Care Inc.
Okay. All right. I hope we got all that. Did we get all that? Miss Latham, Miss Poe?
I got it.
Oh, okay. Oh, that's right. Okay, I didn't think we had a record.
It's not on the record, but I was writing it down on our docket sheet.
Well, thank you so very much.
Yeah, I got it as well, Judge.
Okay, good. That was faster than I could write. Y'all are better than I am. But anyway, I did see that this is Starbucks motion for continuance because they have a case in front of Judge Beery on May 13th. So Ms. Corley.
Yes, Your Honor.
You may
Thank
proceed.
We received Judge Beery's setting notice about 30 days ago, and that is I believe it's a 2019 federal case, which obviously makes it older than this one. That was not a setting that the parties had agreed to, but you know how federal courts are. And in this case, he has set another case on my docket for trial on the same date as this case. And so for that reason, I'm asking that the court grant us a continuance in this case. I believe that our May 13th setting in the Olivo matter is the first setting in this case. But because of my scheduling conflict, and also there have been some recently added parties, We have not completed mediation in Olivo. I believe there are a number of factors that lead to the conclusion this case is not yet ready for trial. We're still working out some discovery issues. And so basically that's the argument, Your Honor, for the continuance of this case.
Okay, any responses?
Your Honor, Katie Andre for two of the defendants. I certainly understand Ms. Corley's conflict and don't disagree with anything that she said. I just, for the purposes of my two clients who were sued first, of the driver and the employer of the driver, I just wanted to say that we want the case to go forward and to be tried, and don't want this continuance, and this is really just for plaintiff's counsel's benefit, don't want the continuance to slow us down. We have a summary judgment on file. We could actually take this case to trial as scheduled, but we understand that there's now 11 defendants in the case. So that's my position.
All right. Thank you. Anybody else?
Well, I can't turn my video on, Your Honor.
That's fine, Ms. Cartwright. You may proceed.
Okay. Your Honor, I mean, I think, you know, the Starbucks is correct. She has a conflict setting, and we do have another quash on, like, a motion to quash that has been filed that's going to be heard after this. And it is Starbucks motion to quash some depositions too. I mean, I think that we just need dates from them, and those dates are kind of dependent on whether or not this judge, you know, Your Honor, grants his continuance or not. So it also would allow more time. It's Starbucks motion to quash their one of their employees and their corporate rep. And then there's been another motion to quash filed. So there's several discovery issues that need to be resolved, along with the new defendants being added and just now answered.
Okay. Because the only motion to quash I read was by Brightview, the Brightview Holdings.
Oh, is that the one being heard today? Okay, that's another one. That also needs.
Yeah, see, we got it quite a bit here. So when is the trial date on this one?
The current date, Your Honor, is May 13th. The parties were able to confer via email with everybody's respective positions being taken into account. Everyone's calendar is open for November 4th.
Okay, how about that? Especially with the late additions and things like that.
That's agreeable to Starbucks, Your Honor. We're available on that date and prepared to go forward.
Even if another federal judge sweeps in?
Hopefully that is not going to occur. This was kind of a holdover case that got deep six during COVID. It was administratively closed, and I think it just kind of came back on the radar. Luckily, all of my other cases have settings, none of which are on November 4th.
Nope.
So I hope this is history that doesn't repeat itself.
Okay. Okay. So everybody's in agreement as to what you said. What month?
November 4th.
November 4th. All right, then we'll continue it till November 4th. Okay, so what about these motions to quash?
Your Honor,
Speaking
oh, sorry.
Starbucks. Oh, go ahead.
Your Honor, and with regards to the
just speaking on behalf of Starbucks, our motion to quash came. I was in two-week trials in Bexar County on February 12th and then again on March 4th. The original dates for the store manager of the Starbucks in question and the corporate rep were going to be while I was in trial. I'm confident that with the new trial date, we can work that out. I just filed the motion to quash, but knew I was unavailable on the date the depositions were noticed, but we will certainly work with all counsel to get those set. That's not a problem.
Okay, so we don't need to hear that.
Your Honor, and with respect to the quash of our own surgeon, Dr. Ocurrs, you know, that was another thing. We'd set that and trying to get it before the discovery deadline. So that would, I'm assuming everybody will be agreeable, and we can of course provide our own new dates for that.
That was not set.
As
far as I know.
Oh, okay. So
yeah, just
I was understanding, but she brought up Dr. Ocurrs quash, so I didn't know exactly. My understanding.
I don't think that was set. I mean, Mr. Hicks can attest to that, but.
Well, it seems like it won't be a problem anyway, and then we can get that set. Or it may not be necessary because you can renotice that deposition, right? Now? Okay, because the continuance probably solved everything.
Yes, Your Honor.
For Starbucks, yes, Your Honor.
Okay, that was easy. We should have taken y'all first. All right. Who wants to do an order?
I'll do it, Your Honor. I had begun one, but I wasn't sure what the court's ruling might be. So I just kind of left it in suspended animation. I will get that circulated to everyone, and then we'll prepare a docket
So
control
check
order
on
to
her.
go with the new trial setting.
I don't know. All right. Last but not least. Do y'all need a record on this UMTH land development?
No, Your Honor, I don't see a reason to do that.
Anybody?
No, Your Honor.
UMTH Land Development LP et al. Versus Buffington et al. This is plaintiff's motion to compel all defendants. Please make your appearances.
Conrad Roberts on behalf of the plaintiffs.
John Patton here on behalf of the general partner defendants.
Your Honor, Dan Byrne on behalf of the investor defendants. And how are you today?
Good, thank you. How are you doing?
Just great.
Good. All right, that's everybody. Okay. Now, this was a very confusing docket and it didn't overshadow this morning's. So can y'all remind me what's going on here?
This is just a motion to compel some documents in production. It's nothing as complex as the things that we've heard over the last couple hours.
Okay. All
This
right.
one is, Your Honor, this one's much simpler than some of the earlier ones.
Okay. And you weren't here this morning. It was crazy. But I think that Warren was really nice to give us these dockets are kind of full, but then we have Friday off. So that was a nice little surprise. So this turned out, yeah, it worked out great.
And Your Honor, to answer your question earlier, I don't ever predict that 66 won't get reached without talking to Mr. Vavra first.
Oh, right. Who knows? He's better at knowing these things than I am, but 66 is a big number.
It is.
Especially for just what? Less than a month away? Yeah, 3 weeks. Anyway. All right. You may proceed.
Thank you, Your Honor. I'll just give you a little bit of background on this. My clients were investors in a large company, Buffington Home Building Group Limited, and that company was sold in July of 2021. The sale went through very quickly, and so my client had some questions as to the veracity of the numbers, how they were actually calculating the amount of distributions and the sale proceeds and where all that money was going to go. They moved for a temporary restraining order. They did not get that, so then this turned into a case for damages. What's actually at issue here is just how were the numbers that were used to make distributions calculated. The defendants are taking the position that they used an accounting firm, Baker Tilly, and they relied upon their professional experience and expertise, and so that makes it as though they acted in good faith. The only question that my clients have is simply, what did you use to make these calculations? We just want to see the underlying documents that can either prove or disprove that the numbers were right. And what we've asked for in a number of requests for production are just those documents underlying that. And we've gotten pushback from the defendants. The defendants have said they've given us thousands of documents, and they have given us a number of documents, but it's not everything, and we aren't able to see exactly what it is that they use to make these calculations. We got a spreadsheet that showed, here's the calculations that we made. Well, I need to be able to, my client needs to be able to look at that and look at the underlying documents and test the veracity of those numbers. And we can't do that until we get all of these documents. So what we're moving to compel are essentially just the documents that they sent over to Baker Tilly. Everything that they sent to Baker Tilly that Baker Tilly used to make those calculations.
And I'm assuming that's an accounting firm?
Yes, Your Honor.
Okay. Thank you.
And all of those documents are, if the calculations were correct, then the defendants can produce those and we can see that the dispute goes away. If the calculations may not be correct, then we need to be able to test that. And so what we're asking for, we've asked for a number of categories of documents, but the first request for production is just documents sufficient to disclose the method by which the accrued administrative fee was determined. Documents relied upon in calculating and or supporting the determination of the accrued administrative fee. There are all of these categories of documents, but basically what we're asking for is whatever you sent to Baker Tilly should be produced to us. If there's an issue of confidentiality or anything like that, then we have no problem with entering into a protective order. We just need these documents. And may I share my screen, Your Honor?
Yes.
See if I can actually do it here. Okay. I produced this morning on Box as Exhibit D. I believe that's not what I'm looking for. I produced this morning, and it's an email that we sent about a month ago. This hearing was actually going to go forward. It was supposed to be in February. Are you able to see that, Your Honor?
Yes.
Okay. So this hearing was actually supposed to happen in February, and we had some conversations. We were trying to work toward a way to resolve this without having to bring a discovery dispute in front of the judge. And we got a little bit of documents, but these are just basic things that we pointed out. Just the general partner defense bank statements, detailed statement of cash flows, the K1s issued to all the other investors, wire ACH check payment details. We've gotten some of this information, but at its heart, Your Honor, all this is we are saying if you send it to Baker Tilly, it should be discoverable so that we can test their calculations. If it turns out that all the distributions were made correctly, there's no case. But if they weren't correct, then we should be able to hire an expert and contest that.
All right. Mr. Patton?
Yes, thank you, Your Honor. So, as we said in our response, this is really not much of a dispute. There's an RFP where they asked for all documents and information provided to Baker Tilly, the accounting firm, that by my clients for purposes of them calculating the distributions. We didn't object to that request, and we believe we've provided that information. And so just to step back a little bit and give the court a little more overview of kind of where we are and why we're here. This is, as Mr. Roberts said, a dispute, I guess, over the sale of my client Buffington Homes. It's a home builder in Austin. Buffington sold itself, essentially all of its assets, in 2021. Mr. Roberts' client is a lender that took a small equity interest in Buffington, less than 3%. One of more than a dozen limited partners in this company. And so when the sale closed, all of the other partners were fine with and approved the sale and were fine with their distributions, didn't complain about anything. Only UDF complained, sued, sought an injunction, and was denied. Why was UDF complaining? Well, behind it, UDF's owners and control persons at the time were several individuals who have since been indicted and are in federal prison for securities fraud and wire fraud for running UDF. And our sense is that this lawsuit is a bit of retribution and retaliation for their perceived, their perception that some of Buffington's principals were involved in that conviction. And so we think that's what's really going on here, because we've bent over backwards to provide them with the information to check out the calculations, see if everything checks out, check Baker Tilly's work. We've provided tax returns, which, as the court probably knows, are generally not discoverable, but we've provided the tax returns. That's largely what Baker Tilly relied on. We've provided the audited financials that we have, the unaudited financials that we have prior to that time. We've provided, obviously, the asset purchase agreement that provides exactly what money's going to be paid. And, it's kind of a complicated deal with the liabilities that are going to be retained or held, and they can look at that. And then obviously they have the partnership agreement, which is how the waterfall is set when the money comes in and then gets distributed. We've also provided them with a spreadsheet that Baker Tilly created. And if I can share my screen, I'll just show this to the court really quick. This spreadsheet has very detailed tabs that Baker Tilly used that go through each section of the asset purchase agreement, and then a waterfall showing the proceeds and how it was calculated. And basically, the proceeds from this sale were then distributed based on a formula that's set out in the asset or in the limited partnership agreement that provides for a certain preferential return to certain investors and different splits between Class A and Class B investors. And this walks through all of that. It cites the different sections here. And so you can really see what Baker Tilly did from this spreadsheet. And we provided them with that from the beginning. We've also asked them in an interrogatory, what's the complaint about the calculation here? Why are we in this lawsuit now 3 years later? Like, what's the issue? And if you don't have the information you need to tell us that, what information specifically are you looking for? And we still haven't gotten an answer to that question. So it's quite frustrating for my client here. And so we asked that the court deny their motion because there's not really a dispute over this. We've agreed to provide this, that there's not an objection for the court to overrule on this request. But we're not just telling them to go pound sand, because we've actually offered to have the in-house accountant for Buffington meet with one of their clients, someone in-house there, whoever they want to meet with her, and she will answer their questions, walk them through in the documents. Here's this information, here's that information, look at this part of the tax return, we'll show you how it was calculated. And if there's any information that's missing, then, she'll chase that down and we'll get it to them. And, I don't blame Mr. Roberts for this, because his client is litigious. I've had personal experience litigating against them in several cases. Their executives are in prison, but we think still running the company. And we think this is more of a spite fest than an actual attempt to get to the bottom of it. And so we think they just chose to push through and harass my client and have this hearing and push the motion to compel. And so we would ask the court deny the motion. We'll still make Ms. Lightman, the accountant, available. And if they have any actual genuine questions about how to calculate the numbers, she can provide it. And then if they have something specific that they can come back to Your Honor and say, hey, we need, this financial statement or something, and it's actually got a missing piece to us calculating what is the basis for our lawsuit we filed 3 years ago, then they can come before the court and ask for that specific information. And so that's kind of how we see the issue and what we'd ask the court to do. And then I'll just finally defer to Mr. Byrne to kind of add for the other defendants. He's been on this case since the very beginning and was involved in the transaction as well.
Okay. Thank you, Mr. Byrne.
Yes, Your Honor. I think it's fair to say that we've already given them everything that Baker Tilly used to generate this waterfall. They looked at the partnership agreement, which sets forth the manner in which the money is supposed to be distributed. Believe it or not, it's quite simple math at the end of the day. What were the sales proceeds and how much needed to be held back to pay bills? And the general partner made a decision about how much that should be and distributed the rest in accordance with the waterfall set forth in the partnership agreement. We're not hiding anything, and this feels like a classic fishing expedition because they're not being specific about what's missing. And again, if they're having a hard time understanding how this all flows, as Mr. Patton pointed out, we've agreed to make our in-house person available to their attorneys to interview. We're not insisting on formal depositions. That's obviously an option for them. But right now, I don't know of anything that's missing, and it's just not complicated. So it's a motion in search of a problem rather than a problem that needed to be addressed with a motion in our view.
All right. Thank you. All right. Your reply, Mr. Roberts.
Thank you, Your Honor. While we understand that there have been documents that have been produced, there has been a rolling production, things that have come through, things that were produced, excuse me, in, I believe it was in November, and then more documents produced in December, and then more documents produced just last week. And it's always this rolling production. We think that maybe this will actually answer the question. And the very basic heart of what we've been asking for from the very beginning is, what did you give to Baker Tilly? If a document went to Baker Tilly to help them to make these calculations, they're discoverable and they're responsive to numerous of our production, and there isn't any objection as to whether or not we actually asked for this stuff. If they're stating today on the well, there is no record, but stating to the court that they produced everything that's been produced, then that could also have been answered in response to the motion to compel, or somewhere in writing to hold them to the argument that we've given you every single thing that we gave to Baker Tilly.
Okay, so why, Mr. Patton or Mr. Byrne, if that's everything, then why has there not been a supplemental answer or response to production? You know, this is all we have.
The short answer to that is that specific ask has not really been pushed in our meet and confer or anything. Really what's been pushed is what was in the motion, which is just documents sufficient to show how the distributions were calculated. And we've been focused on that. And I mean, we, you know, as Mr. Roberts pointed out, we've gone back and produced more documents when they've asked questions about things, and have asked for more to show, you know, past calculations and everything we can. And so if that's the ask, you know, we can definitely amend that response, confirm with the client that everything responsive to that request has been produced, which I'm happy to do. I'm going to do anyways, now that it's kind of been made the forefront of this hearing. We obviously didn't raise any objections to the request. So there's, as we see it, there's nothing for the court to rule on, you know, at this point.
Okay. And then there's also been an offer for plaintiff to interview in-house counsel, and of course plaintiff could notice the deposition or subpoena in-house counsel as well.
In-house accountant, Your Honor.
Accountant, yes. Sorry. Oh. What would the underlying documents, I mean, because sometimes we have these kind of issues, like in summary judgment, people will throw up a spreadsheet and say, here's everything. But, you know, it didn't show that they paid the plaintiff, or it didn't show any check stubs, or it didn't show this or that. So what are the underlying documents that you believe are necessary to, for your case that they haven't?
Well, Your Honor, there, you know, as we said, you know, in the email that I sent to Mr. Patton back in early March, you know, just seeing some full accounting of where the money was going during the time of the sale, money that came in, money that came out, who it was going to. We received some bank statements, but they're not as enlightening as I would hope they would have been. We've asked for a general ledger just to see, you know, where the money actually came from. There are actually somewhat of a question as to what the final sale price was, because what was explained to the investors does not appear to be what the actual final sale price was. It was sold to a publicly traded company. They listed at a different amount than the original $27 or $45 million that we were actually told. And so what we're just trying to do is just get to the documents that they've given to Baker Tilly. And if there's an answer that this is all we've got and this is what we've given them, then we would probably be in a different situation. Obviously, they have offered up Ms. Lightman for an interview, and I'm, you know, working with Mr. Patton and my clients so we can set something up to figure that out. But to my knowledge, this was the first time that I've actually heard we've given you everything, because every single time that we've gone after something and tried to, you know, figure this out, miraculously more documents show up.
Well, I mean, was it the K1? Is that what they're called? I mean, you got that, you've got the tax returns, you've got the flow chart, you've got an offer to meet with the in-house accountant. It does seem a little bit like, I wouldn't call it a classic fishing expedition, but just give me everything, you know, possible that has to do with this sale.
Completely understand Your Honor's position on that. As I said, you know, if we had discovery responses that said we've given you everything, points to the documents, then I don't think we'd be here. The issue is really, we're asking, give us everything that you gave to Baker Tilly. And if they're not telling us that they've given us everything, that's why we ended up here. But it does appear from, the statements of counsel that maybe they have given us everything, and maybe we do need to go forward with this interview with Ms. Lighton and figure out if there's anything else that may still be out there we can't calculate. But again, the reason that we were here today is just because we hadn't heard previously that they've given us everything.
Okay.
Runner, if I can direct the court's attention to one thing just to reinforce this. An example is Mr. Patton's client's response to request number 26, which is attached to their motion. All documents relied upon in calculating or supporting the determination of the amount issued by Buffington payable to UMTH. And the answer is no objection. We'll search for and produce documents within our possession, custody, or control. I mean, that's everything. There's no objection there, and that's what we are saying these parties have complied with.
Your Honor, if I may, the point that I'm trying to get at here is simply that we will search for these documents and produce them is not the same as a response that actually states we have produced everything. And so that's how we've ended up here. I don't want Your Honor to think that we're actually just chasing something.
Well, when does discovery close?
We currently do not have a docket control order in place, Your Honor.
So you go by the rules.
Yes.
Which means it closed a long time ago.
Okay, so that means that their answer is that that's everything. What do you feel like you're missing?
Your Honor, again, I the entirety of this, what has been just because there's a vagueness out there as to whether or not they've given us everything that they gave to Baker Tilly. And I understand where Your Honor is coming from at this point, and your point is well taken. That they're saying now that they've given us everything. I don't want to just tuck my tail and run out of the office here, but they're saying to Your Honor and representing to the court that they've given us everything, and so we can just go on with interviewing Ms. Lightman and move on from there.
Well, right, and you might discover something there that you didn't get, I guess, if she were to sit down with you and go through everything. So I'm going to deny the motion.
We'll keep working, Your Honor.
I'm sorry?
We'll keep working to get him whatever else he thinks he needs.
And I mean, things come up in supplements or something, but sometimes things get found that weren't before. But I get what he's saying. He'd like a general ledger, but to make somebody cough up a general, he didn't ask for a general ledger, but to make somebody cough up a general ledger is, you got to come up with a better reason, I think. But so do we want to put something in the order that the parties agree to conduct how many hours with the in-house accountant?
Your Honor, I don't think we need that in an order. We've been offering that for weeks. I
think we can tell you, honestly, it's very helpful to have the focus on what was provided to Baker Tilly, which is our RFP 14. And so now that focus has been highlighted, I will circle back to that RFP with the client, shake the tree and make sure there's nothing else, and then amend our response to it to tidy all this up. And I think that should resolve the issue.
Okay. Well, good. I'm glad that y'all were right. That was easy. All right. So
Your Honor, do days like these make you look forward to getting off the bench? Yes.
Well, actually, it's been really nice. I like my job, but I'm 62 and I have 3 daughters and a granddaughter, and I've worked all my life. I've had a job since I was 16. So, some people would say, well, apply for this or try to get that. And I'm like, you know what? I don't know how much longer I could traipse around Europe with all these girls, or go look at Machu Picchu or, those kind of things. So every time I think about, well, I could do that, I just go, no, This is it's so much fun, you know, and we're on YouTube. So, you know, there's other personal things like with the, you know, my mother passing and everything and her long illness and everything. And, you know, I love doing this. I think I'm good at it. I think people like me. Some people were like, you know, you came in third. I was like, yeah, but 12,000 people went and voted for me that didn't know me. I had no signs. I didn't ask for any money. I mean, I asked 2 people for money and then I was like, you know what? I don't want to ask anybody for money. You know, it's been.
Didn't you decide at the last minute weren't you
yeah.
not going to run and then you went for the last minute and decided to give it a go?
Yeah. I just couldn't stand not knowing, you know? And
Okay.
it does give people information about, you know, what works and what doesn't. And, you know, there were 3 of us and, you know, I just thought it was really interesting. And I think that I've been a good judge, but you know, you know, there's a lot of more things at play and it was something I wanted to do. I didn't have anything against Judge Sulak. I just saw an opportunity and it's been really fun. And I mean, you know, your wife hadn't reversed me that often, you know, so I must be doing okay. So anyway, I appreciate it. And y'all, so get that order to Ms. Latham so we can get it out there and to Ms. Price.
I think it's already been submitted by email, Your Honor.
Oh, okay, great. Great. That's wonderful.
From Mr. Pat. Mr. Pat.
Good. Well, thank you so much, Mr. Roberts, Mr.
Thank
Patton,
you.
and Mr. Byrne. I hope y'all have a lovely week.
Thanks. You too.
Thank you, Judge.
Okay. Well, great. Well, thank you all very much.
Thank you, Judge. Are we excused?
Yes, y'all have a great week.